My apologies for ringing the bell twice. David Cleandon.
Thank you, Mr. Speaker. Tēnā koutou katoa. Mr. Speaker, this bill depends upon one key assumption, and that is that Māori rights are derived from the Crown, and by extension the government of the day acting on the Crown's behalf. The provisions of this bill only make sense if one accepts that primary assumption, and as it is one that the Green Party does not and cannot accept, we cannot offer any support to this bill. I will speak later in this debate and in following reasons about some practical and specific concerns about the bill, but it's necessary to first establish our core positions and the reasons for it. The starting point for legislation of this sort must be that prior to 1840, Māori exercised sovereignty, were sovereign in Aotearoa, New Zealand. The leaders of iwi and hapu exercised legitimate authority, and that was acknowledged by the Crown in the Declaration in 1835, and by the acknowledgement a year earlier that the Crown of the flag of the Confederation gave vessels flying that flag rights of passage and commerce in international waters. The signing of the treaty in 1840 saw Māori cede kāwanatangi, governance, to the Crown, and in exchange the Crown guaranteed to Māori tino rangatiratanga, chieftainship, the right of Māori to control their lands, their villages and their other treasures. So the base of all negotiations must be that Māori held recognised sovereignty rights and continue to hold those rights unless the rights associated with that sovereignty have been legislated or alienated by some legal and defensible means. The Ngāti Apa claim made by the Marlborough Hapu that led us to the Foreshore and Seabed Act was essentially that they had ongoing rights in the foreshore and seabed, and that those rights were being ignored, and the iwi sought to take their claim to the court to be tested by the legal process. The courts indeed ruled that there was a case to answer, and that led to one of the few instances in the 9 years of the Clark-led Labour government when we saw a response that could be described at least as a knee-jerk and even a panicked response to that situation. The choice was made to follow a legislative course, was taken to prevent a legal claim being taken to the court. There was a choice made that Māori should be denied their day in court, and that might prove or disprove Māori claims to continuing right in the foreshore and seabed. And this legislation we're debating today, that is introduced today, while posing as a new approach, effectively does the same thing. It starts from an unproven and an untested assumption that the Crown has primary rights in this area, and that any claim must be made from that basis. It puts any Māori claim to rights will be tested against an incredibly high bar, an unreasonably high bar, that is unlikely to be surmounted or to produce meaningful or positive result for Māori. An alternative view, an alternative base assumption is that Māori do indeed have existing sustaining rights, and that the onus is on the Crown to disprove Māori rights in the foreshore and seabed. And such an approach, such a core assumption, puts a very different complexion on the debate. It is worth recalling in passing that Ngāti Apa's pursuit of legal remedy in 2003 was an endeavour to gain access to resources to build an economic base. There is constant criticism of Māori that we are overrepresented in all the negative social statistics, and yet so often when Māori seek to establish some economic activity, when there is a nascent expression of Māori enterprise, Māori entrepreneurship, that too is condemned as an example of allowing special privilege or requiring special privilege, rather than an expression of fulfilling the provisions of the treaty. The history of what followed in 2003-2004, that followed the decision of the government of the day to circumvent proper legal process, is well known, and perhaps best remembered for the massive protest by Māori and non-Māori alike, the scale of which had not been seen for decades, and of course to the establishment of the Māori Party as a force in Parliament and in the wider community. The National Party has much to regret and perhaps even should feel some shame at some of its pronouncements and its actions since the debate began, or began again in earnest in 2003. Some of that party's actions and statements fueled divisiveness and fear in the community in 2004, and in the following year exploited and even encouraged anti-Māori sentiment over the foreshore debate as an election tactic with the use of the Kiwi Iwi billboards. The current Prime Minister said in the House that Māori lost nothing under Labour's legislation because they never owned it in the first place. This government nevertheless came into power, promising, among other things, to repeal the foreshore seabed legislation, and technically they have fulfilled that promise. The legislation on offer, however, to replace for foreshore and seabed differs in name only. The bill has a new name, but in essence is the same as what it seeks to replace. It just papers over some of the worst cracks. It marries together Labour's foreshore seabed bill and Labour's negotiations with Ngāti Porou into one bill with a bland name. All injustices continue. The legislation remains manifestly unjust and treats Māori and Māori customary rights as inferior and second class. Māori remain in this bill second-class citizens. They do not have the same access to the courts to determine their property rights as holders of property as private title. Their customary title is determined not by tikanga but by the government. The government continues to own the foreshore, or to at least assert ownership of the foreshore. The construct of common space or non-ownership deceives no one. There are two sets of Crown-derived orders, accessible either through the court or through direct negotiation. And the rights within those orders are determined by the Crown and are less than the right held by existing fee-simple owners of the 12,500 private titles in the foreshore and seabed. Large iwi with significant resources can make claim to the mana Moana held by small iwi, thereby entrenching injustice. The bill extinguishes customary rights of operation by operation of law without the consent of the customary owners, because the rights can only be obtained through legislation. This bill replaces an unjust piece of law with an equally unjust law. It uses different language, it wears different clothes, but in essence it is the same. It seeks to reduce Māori to the status of supplicants in their own country, allows the exercise of customary title only by grace and favour of the Crown. A very different approach is required, and we will continue to advocate for that approach based on common law, based on natural justice, and through honouring of the commitments made by both sides of the treaty relationship. Kia ora koutou.